What was the difference between Hopcraft and Wrench and Johnson? If Johnson didn't get put with Hopcraft and Wrench, what do you think would have happened?
Great question. I had 45 seconds out and I thought I know what to say. I've won 5 times in the Court of Appeal and I've won twice in the Supreme Court. I've helped millions of consumers.
The only purpose of Johnson is to protect consumers.
Yeah, my message to the FCA, it was rock solid. We're not a podcast in the world that's talking about these issues. When I was sat there side by side in the Supreme Court, we faced the music and now the hard work really does begin.
Kevin Durkin, HD Law. Okay, Kevin, so probably massively anticipated by everyone who's probably going to be listening to this. I know your Court of Appeal Johnson breakdown, the first podcast we ever did together, is still our most listened to podcast to date. So I think without any further ado, let's kick off. First of all, congratulations. I mean, if we're to go off anything that we've read in the newspapers over the weekend, everyone's saying it's a massive defeat to car drivers in the UK. They're trying to make out that it's a massive loss for consumers and a massive win for the banks. I mean, we were sat on Friday having a curry with Rob Weir and Jonathan Butters, and there was nothing but celebrations on our table. So do you want to just sort of break it down from us meeting outside the Supreme Court on Friday to where we are now?
Yeah, I have to say you're one of the few who has congratulated.
Well, I think you actually have to know what you're talking about,
yeah.
And what's actually happened over the last 5 years to be able to recognise it's a win, don't you?
Yeah, so just in summary on that point, my case of Mr. Johnson's unfair relationship claim was successful. It survived the appeal from the banks, and it's created a pathway for drivers in his position. If I cast my mind back to Friday, which seems like a lifetime ago because so much has happened, first of all, we had the unprecedented step of the Supreme Court deciding to deliver the judgment after 4:30. The reason for that was to ensure that there was no disruption to the markets. That was something that the appellants requested in the case. We took a neutral stance. And the FCA also weighed in and said that would be beneficial to the market. So I got the train down Friday afternoon. Very strange to be going to court when everyone seemed to be going home. That was an odd feeling. I went to Chambers, spoke with Jonathan beforehand, and then got the tube across to Westminster and met up with yourself. It was a bit like the first day of the Supreme Court hearing with all the press outside.
I was going to say, it was the atmosphere outside the Supreme Court on Friday. I mean, considering it was, I think we arrived at court at 4:00. Obviously, there's loads of tourists in London anyway in August, but the camera crews, I mean, I think I counted about 7 or 8, BBC, Sky News, ITV, the Associated Press. They all had the lights, they had the actual presenters there, the branded microphones, the branded umbrellas. There was quite a buzz there, wasn't there? And obviously that was attracting a lot of tourists to sit there, watch, get the phones out, ask what's going on. So do you want to just start with, like, how did that feel for you?
There was tension in the air, if I can put it like that. It was different from the first day of the hearing itself, in my opinion. That there was a bit more energy, I'd say, on the first day of the hearing. This was a bit like slightly subdued, but everyone knew it was going to be big. Yeah. And again, it just feels to be strange. It's a bit of an out-of-body experience that you're looking at it and you're thinking, this is a lot. And you think, oh God, it's my case. I've got to go in there and receive the judgment. I didn't do any press outside before I went in. I just felt uncomfortable to some extent talking about the case in too much detail before I had the judgment. I'd rather have received that. And then you and I just kind of soaked it up, really, didn't we? And then just as it started to rain, we quickly got inside and found courtroom 1 where the hearing took place. Which was where the hearing took place, exactly, yeah. So you kind of feel, there was a lot of people commenting before the actual judgment was handed down on Friday. And I think we spoke maybe just at the start of this year that said, the whole
after April, after the hearing, everything is now speculation. So it'd be kind of inappropriate to comment. And there was an air of going into the court where it was like, well, what is going to happen? Because we had obviously the Treasury attempt to intervene in April. Then we had Rachel Reeves come out in The Guardian and said that she might look to overturn the judgment if it's not favourable for the banks. There was obviously lots of press saying that it's going to destabilise the market. So there genuinely was almost that element of conspiracy theory in the back of your head as well as to what's actually going to happen here, wasn't there?
Yeah, you did worry how much of the noise and racket that was being created by the lending industry and the government. The government.
Yeah, the
I'll say it
Labour
again. Yeah. The Labour government, who traditionally is meant to be on the side of the working man or woman. You did wonder how much of that was going to bleed into the decision-making of the court, because justice doesn't happen in a vacuum. There are political factors that can be taken into account, and the smell or aura created by the lending industry, like you say, that it was going to cause the second credit crunch, which I thought was preposterous, and a little bit disingenuous that we've created this mess potentially with the way in which we've sold car finance. There was something there, but if you punish us for it, it was a bit of a threat. Well, if you do that, then you're going to crash the economy, and you best not do that. So please let us off the hook to some extent. So I did sit there, and a lot of things were going through my mind. Particularly, you and I went into court. We sat on the same row that I was sat for the hearing. There was some of the legal team, I think for Close, who attended and were sat to the right, as appellants do traditionally, in that context. And then the three judges came in, and it was a bit like showtime. It felt like starting gun of a race, really, when they came in. Yeah,
I was going to say, the atmosphere to me felt like as serious, if not a bit more serious, than those 3 days that we spent in courtroom 1 in April.
Yeah.
And obviously Lord Reed didn't waste any time getting into it. They, all rise, and we sat down and straight into the judgment. I was obviously sat right next to you, saw you scribbling your notes frantically. Just talk us through sort of, as Lord Reed started speaking, was there key moments in the delivery of the judgment that sort of made you think we'd lost or we'd won, or, what was going through your mind then?
Well, first thing, we were being live streamed on Sky. And BBC, which is a first for both of us, I'm sure. I guess it's like whenever you get a judgment extempore from a judge, you are listening to every single word, and you're trying to guess which way it's going. And I think initially he was down the line, but then as he started to mention representatives who had advertised for potential claimants following the Court of Appeal judgment, and gave the angle or the opinion that this was a bit premature, I started to think, oh dear, this seems to be going towards the banks, because I understand what the Supreme Court was saying, but my view was, well, the Court of Appeal judgment was law, and there's nothing wrong with following a Court of Appeal judgment and seeking to get clients who fall within that judgment as potential clients. Now, obviously, that can change with the Supreme Court decision, but it also cannot. Sometimes the inference can be, well, the higher up you go, the judges are generally aligned. I know that's why appeals happen, because judges aren't aligned, but the odds we felt at the time favoured the Court of Appeal decision being upheld more so than it was. So when I heard those comments from Lord Reed, I started to think, not that we completely lost, but I thought we hadn't won in terms of a complete endorsement of the Court of Appeal decision. And then it turned out to be exactly that, subject to the, obviously, Johnson unfair relationship element surviving, albeit with a few tweaks.
Yeah, and I think it's important that we need to circle back to that moment with Lord Reed addressing claims management companies, because a lot of people, I think, have forgotten that the Court of Appeal, the unanimous Court of Appeal decision, was the law up until 4:35 on Friday.
Yeah.
There's absolutely no ambiguity about that. And the inference that claims management companies and claimant-focused law firms had jumped the gun in terms of onboarding clients or sending out letters of complaints or claims, whatever you want to refer to them as, it was completely, from not what I expected the Supreme Court to comment on.
I didn't either, because they were quite firm to say that we are shutting out.
Mm-hmm.
This is a court of substance. We will address the law, but then at the same time made reference to what happened outside. And also as well, there's not really much, even if you were to onboard a client, everything was stayed. It wasn't like anything could have happened adversely to a lender. They could have said, okay, we've got your complaint. So there was no damage being done to the lending institution for clients being signed up. And it's a product as well, I have to say, of the legal system within which we work. There's no legal aid for people who are victims of car finance mis-selling. They need to get, in my opinion, the best possible opportunity to seek compensation. That is through a law firm, because that's how Mr. Johnson got his compensation. We wouldn't be sat here if it wasn't for Mr. Johnson instructing a law firm and then being guided all the way through. So I was surprised to hear that, I have to say. Going back to one of the questions that you asked about the notes, yes, and obviously we can't talk to each other too much in court other than whisper in each other's ear, but I was frantically writing notes almost to try and dialogue with myself, but you and I then did dialogue through notes, and I think I wrote down unfair relationship survives, and then you wrote Hopcraft Wrench lost, ? Johnson won. Question mark, and I just ticked. Yes, you're right. Yes, you're right.
Yeah, because there was a key moments when he was delivering it, and I was like, okay, we've won. And then Lord Reed immediately said something that made you go, whoa, have we won?
Yeah.
And you was constantly back and forth, and I don't think from the initial, and I think we'll move on to this exact point in regards to the headlines, I think the delivery of the judgment on Friday after market hours. And bearing in mind, a lot of people don't realise that you, as the solicitor for Mr. Johnson, and obviously Rob Weir and Jonathan Butters being the lead counsel, you would normally get this judgment embargoed a week in advance.
Right, yeah.
You would have normally have had a good 7 days to digest the judgment, understand it, pros, cons, what's exactly happened.
Yeah.
And I think having to digest the 30-minute speech by Lord Reed to then come from court one down to the press, which is probably about a 45-second walk.
Yeah, down the stairs.
A straight line, to come out and then comment on what's been earmarked as a landmark case for finance, consumer finance as a whole. It was almost overwhelming, and I think we both agreed, sat having something to eat with Rob and Jonathan, and we said this has been so poorly communicated immediately by the press, and the expectation that you can comment on it in such a detailed way to separate that Hopcraft and Wrench are their own kind of claims, and Johnson is and should be treated as its own standalone. Do you think that the way that, or the unprecedented way that the Supreme Court delivered this at the request of the banks has kind of caused the confusion that we're now seeing in the market?
Definitely. The way I describe it is, it was totally unprecedented. Usually, as you quite rightly say, I have a week's notice. In Potter, the other Supreme Court case I did and won, I knew the week before I was embargoed. I could only speak to counsel Jonathan Butters and Rob Weir, KC, about it, and you're looking through it, you check for spelling mistakes, typos, you tell the court, and then they read it out the following Wednesday. But you sit there thinking, I know I've won, because I've read the judgment, and you're listening to the press summary. And you won. Like saying this one, I was in the same boat as everyone else. I knew absolutely nothing until Lord Reed started to speak at 4:35. And because there'd been such a build-up and it was so unprecedented, it was on a Friday afternoon. I've never been that late in court, I don't think, on a Friday. Usually judges like to finish before 4 on a Friday, and why wouldn't you? But it was a bit like bullets had whistled past my head, and I was kind of looking down thinking, I don't think I've been hit. Checking myself, actually Johnson's won. And then within the 45 to a minute I had walking down the stairs to get out of, my brain started to pick up, and I thought, this is great news. We've got the pathway. Mm-hmm. So when I came out, and I did press with Sky News and I did press with BBC News. Now, I've not seen any of that, and no one's told me I was on the telly. And if anyone at Sky is listening to this, or the BBC, I would very much be interested to see what you filmed of me, because I don't think that went out. Now, the reason I don't think it went out is because it didn't suit the narrative at the time. Now, the buzz story is lenders crush claimants in appeal, drivers hopes dashed, whatever you want to call it. You know, you could use drivers have a roadblock put in place. And I come out all optimistic. I can remember what I said. I had this phrase that popped into my head just as I come out the doors of the court. I thought, I'm going to say it in 3 ways. I said, I'm delighted for Mr. Johnson, first and foremost. He's had 4 hearings in just under 3 years, and he's finally been vindicated, and he finally gets to keep his compensation and can feel that he's got justice finally, despite his lender pushing him and pushing him and pushing him. And then I said I was delighted for the team at HD Law, delighted for Devro, Rob Weir, KC, Jonathan Butters, Tom Westwell, name-checked them. And I said, finally, I'm delighted for all consumers who are in the same position as Mr. Johnson, who now have a clearly defined pathway in order to bring an unfair relationship claim. And I was, as I was saying those words, I started to hear myself. I thought, this is great. And then I did the BBC one. They asked me to re-record it because traffic went past. They'll definitely use that. But I'm not sure, because then we went out and we had a debrief with Jonathan and Rob over a curry, but I don't think it went out. And what I did see was, and I have read since, is that we're disappointed narrative. And I'm a bit perplexed and perturbed as to why that's being spun, because it's misinformation. There are 3 routes that were presented, bluntly speaking, to the court in order to get a shot at compensation. And the courts have, in my view, just said, you just choose that one. And in my opinion, that's the more simplified, easy to understand in a legal context. You know, Section 148 to C is something that's been my bread and butter for the last 18 years doing PPI. And I was delighted. I thought, great, this is where we go from there. But as you say, there was this, and it's still there now. I mean, I gave The Guardian quotes. I gave another outlet quotes. They didn't use it. Mm-hmm. And I was referred to as lawyers, generally speaking. I thought, could you not at least name check HD Law? The only people who were name checking HD Law were you when you spoke to ITV, when you spoke to GB News. You were the only person who was able to get it while you were being live and get in there. I was trying, but they were chopping me out. I couldn't believe it.
Well, I think it's really important that as well, because I think everyone I've spoken to, and I've done quite a lot of press over the weekend in your presence, and the separation between Johnson, Hopcraft and Wrench is not being done. And I think that's through, one, not lazy journalism, but I think obviously quick journalism. They've not sat there and done the research properly. And they've also, it's kind of played into the narrative that the banks wanted, the government wanted, and so on, that there's this massive loss. And ultimately, reporting the loss causes consumers to have this confusion. And then there's, again, it was the exact same when we were sat here last October, October 2024, when we was talking about Johnson. And this was the first podcast we'd ever done. With the PR strategy wasn't in place, we were sort of no names. And we was on the back foot again, and we spent the last few months of 2024 and first quarter of 2025 going hard on the PR to explain in layman's terms what had actually happened. And I think what we're seeing here again is another carbon copy of that, but much more aggressively, to make or cast doubt into anyone who's filed a complaint or filed a claim that you probably are not owed anything, or what you thought you was owed is going to be, I mean, to quote the FCA piece on Sunday, less than £950. So I think it's definitely been orchestrated, and the way that the media immediately had those press releases out and the titles, it definitely felt like there was an ulterior motive other than to just report on another. Let's face it, this is no more or no less important than anything that arrives at the Supreme Court's desk. If you think that the Supreme Court's there to rule impartially, look at the law as Lord Reed said, whether this is a consumer finance piece or something to do between two massive behemoth entities, it shouldn't have been treated any differently by the courts or by the press, but it actually has done. And I think that frustration definitely transpired, or grew, should I say, over the weekend when I saw you speaking to The Guardian and the emails that you were sending for the quotes, and they were very well-articulated pieces, and it was very layman's term explanations coming from yourself, and they just completely disregarded them because it didn't fit the narrative at the time. And it's only until probably Sunday when we did BBC Radio London that they were like, oh, you guys are saying something different to what we've been saying. Can you just explain why you think this?
Yeah.
And then once we explain it, they go, that makes sense. I mean, I had one with GB News where they said, so is our car insurance going to go up in price now? So that shows the level of understanding the media's currently got at the moment. And obviously can't tarnish all the media, but you can see it was from the second the judgment happened at 4:35, the press immediately wanted an expert comment on it at 4:50, 5 o'clock, and there's not been this breathing space.
I think the way I look at it, it's snobbery, and it's snobbery on two fronts. Snobbery towards ordinary drivers. Initially, do you remember we commented on some of the pieces on one of the previous podcasts where it was a bit like, you've been missold, you've got your car, shut up, get on with it. So there's snobbery on that front that, are you claiming compensation? Or can't you just crack on and accept you've been missold, and what's wrong with commissions?
You're just happy with it.
Yeah. And then I think the snobbery in the press towards our industry of, ambulance chasing law firms are getting involved. I'm sorry, but if it wasn't for us, there wouldn't be any claims process at all. The FCA were rejecting my fixed fee complaints prior to Johnson, and now they're talking about my case and they're going to put a scheme in place. And it's almost like they're wanting to run out in front and say, well, this was our idea all the time. So I do think it is that snobbery, and I think it permeates into the press. And when it comes to editorial cut or whatever, they don't want to promote the fact that no win, no fee solicitors, no win, no fee, we don't get paid unless we win. So that's a bit of a fair deal, are a bit unsavoury, and they don't like their involvement in this, no matter how fundamental and crucial it is. And I think that just comes out in some of the stories, and it doesn't suit the narrative of the press. And then obviously you've got unqualified people like Martin Lewis saying that you don't need a law firm, do it yourself. What a silly thing to say. What an absolutely irresponsible thing for someone who's obviously got his place as a media mouthpiece to say on the back of somebody who did use a law firm and went all the way to the Supreme Court and created a precedent. He seems to ignore the fact as well. Firstly, like you say, the £950, well, I don't know where that figure's come from, but it looks a bit on the low side to me.
And to me.
On first blush, based on averages that you've got, and I've seen the hundreds of cases you've successfully concluded and drew averages from, and my book as well. And also, why would you be bothered doing all that paperwork yourself in any event? Well, even if I could, we keep saying the same analogy, I could wash my own car. Why isn't Martin Lewis going around saying, shut these car washes down? This is outrageous. People can wash their own cars. You don't need a car wash. Do it yourself. Or, you get any kind of claim that, delayed train journey ticket. You can't be bothered. You think, I just can't be bothered. If you want to hand that over to someone and they do the hard work for you, give you the benefits of legal protection and get you the best possible opportunity for compensation, don't they deserve paying for a fee? You've got no problem paying for somebody else, like fixing your car, for doing work for you or washing your car. I just don't get this aversion to lawyers being paid for doing classic lawyer work, which is recovering compensation following a Supreme Court decision. And the other thing, sorry, I'm on a bit of a rant here, but you talked about the impact of the case. It's one of the biggest, because if you think about it, how many people have been affected by this? 31 million?
31.7 million.
That's roughly half the population. Half the population have been affected by this decision. This decision has been won and supported by claimant lawyer firms. I couldn't have done it without the support of Sentinel, without the support of other law firms. We've done it. We've created this precedent. And then now it's like, thank you for that. Can you move out the way now?
Mm-hmm. Well, can I ask you something? Let's just talk the reality about Mr. Johnson. So when did you first take Mr. Johnson's case?
September 2022.
So September 2022. Could Mr. Johnson have taken that to the county courts?
On his own?
On his own.
He could have had a go, but he'd have been, I think, either struck out or completely outmaneuvered by the solicitors that his lender would have paid privately for. Mm-hmm. An established, experienced law firm, they've outmaneuvered him. But stunned if a litigant person could have done this.
So, for absolute clarity, could he have represented himself in court on that day in the county court?
He could have, but he'd have lost because he'd have been up against an experienced law firm. If he hadn't have, he'd have had to have filled in the forms, done his own witness statement, quoted the law. I mean, if you've got all the way up to there, he should start his own law firm because he'd be doing lawyer-like work. But the reality is no. Yeah,
no. I mean, you could do it if you had the level of knowledge and understanding to do it. And I know firsthand the level of defence that these banks have put on for small trials. I mean, sometimes I've seen adverse costs awarded for the other side in excess of £3,000 for a small trial.
Where there's the solicitors acting on the other side.
Exactly,
it's a level playing field.
It's a proper barrister, so then just on that, he's lost at county court. Could Mr. Johnson on his own then appealed that?
Again, he could have if he knew how to Part 52 operates and filed a permission to appeal, drafted his own grounds of appeal, quoted the necessary law in order to demonstrate how the judge had erred. Yes, he could have. But again, if he's doing that successfully, he should be doing a law degree and starting his own law firm because he's that good.
He's not the unsophisticated individual that Lord Reed described him as. So then it arrives at Court of Appeal. Mr. Johnson's representing himself. Could he then speak in the Court of Appeal on his own?
No, he wouldn't have rights of audience.
So he doesn't have rights of audience. So technically speaking then, Martin Lewis is completely incorrect in saying you could do this on your own, because you could try and do this on your own, but there wouldn't be anything to do, because Mr. Johnson's case would have never happened. It would never have been appealed to the Court of Appeal. It would have never have had the unanimous decision at the Court of Appeal and have effectively become law for the best part of 12 months. And then ultimately would have never have gone to the Supreme Court and set the precedent that we now have in regards to unfair relationships.
Correct. Now, if, as Martin Lewis would probably say, he could have lodged a complaint. I lodged hundreds of fixed fee commission complaints with 25 pages of case law, case study, supporting each complainant's fixed fee. Every single one of them from the FOS rejected. Every single one.
Yeah, so it's not as cut and dry. And I think I did actually the figures over the weekend for Sky News, and during PPI, the lenders with a redress scheme actually rejected 45 to 50% of all complaints under a redress scheme. They went to the FOS. 80 to 90% uphold rate, but what was the catch? It was about an 18-month delay.
And the redress scheme, when it was on foot with PPI, gave terrible payback. It gave you the amount of undisclosed commission above 50%. So if you had a commission of 75%, you got 25% back. You got a quarter of the money you've paid towards PPI. It almost makes mis-selling seem like a good thing to the lending institutions. It sends out the message, look, you can mis-sell. There might be a court case in a few years' time. Keep your profits while that's going on. We'll ask for stays. Use the profits that you've made to instruct law firms to slow it down. And when there is a redress scheme, it's likely that you won't have to pay all of it back, and you'd still be able to keep 3/4 of the profit that was unfairly made.
So let's just clear it up for absolute clarity now. Let's do the separation between Hopcraft, Wrench and Johnson, because this is very, very, very important. What was the difference between Hopcraft and Wrench and Johnson?
Well, let me take a step back. So Johnson was the first case that got permission to appeal from the Court of Appeal. And that was in late 2023. So that stood alone. That was on its way to the Court of Appeal on its own. And then there were two other car finance mis-selling cases, as you've mentioned, Hopcraft and Wrench, which had similar facts, but the areas of law which they relied upon for want of a better phrase, were different. So that involved secrecy, bribery, breach of fiduciary duty, accessory liability, breach of disinterested duty. So to put it in layman's terms, it was relying on the older law, the more archaic, traditional English law. It's important to state that the unfair relationships is a species of European law. It was an EU directive in the early 2000s, which made its way into domestic law. And in 2006-7, the Consumer Credit Act changed, and you had the introduction of Section 140A to C, which is basically the unfair relationship provisions. And again, in layman's terms, it was just a more modern way to allege someone had done something wrong. You didn't need to get into these historic breach of fiduciary duty and tort of bribery, which are very old-fashioned, belonging under the century words. I mean, how often would you say, bribery and breach of fiduciary duty in ordinary conversation? You'd say that's unfair. You'd see anything in everyday life. You go, that's a bit unfair. So those two cases got tagged on to Mr. Johnson, for want of a better phrase, again, because the court thought, right, well, we've got three cases. They're covering all areas of law, all heads of law, heads of loss. So we'll hear them all together. And then that's why you got this kind of trilogy of cases. But it was Mr. Johnson was out in front and he was alone. And then Hopcraft and Wrench caught up and became this kind of package.
So the court basically tried to say, listen, if we're going to talk about car finance claims, let's cover every eventuality in one hearing. And that's why ultimately it happened at the Court of Appeal and ultimately the Supreme Court. Yeah,
and it's a good idea because it just clears everything up once and for all.
You don't have a it is probably the wrong analogy, but you don't have a PPI Plevin type scenario.
Well, in essence, Plevin just cleared everything up. And I'll say that's what Johnson's done. We'll get to that. But in Plevin, it just established if you have a PPI claim, it's unfair relationships. And it was very simple. It was, the FCA understood it. I don't agree with the scheme they set up because you only get a quarter or a third back. But it was very easy to apply because it was just a simple analysis of, is this unfair? What factors make it unfair? If it's unfair, give them the money back that makes a relationship fair again. Tort of bribery and breach of fiduciary duty, which is what the Hopcraft and Wrench cases brought to the Court of Appeal. As I say, we're a bit more traditional, a bit more old-fashioned allegations that, started off in another century. But they got added on. And then what happened is there was a resounding win in the Court of Appeal. So we had a clean sweep. It was a complete unanimous decision. So that then obviously goes before the Supreme Court. And what they've done is they've peeled back Hopcraft and Wrench and with those allegations, and then just allowed Mr. Johnson, said no, that was the right claim to bring with the right facts. There's a little bit of tweaking they've done, and they've given the award.
So what would you say, hypothetically, if Johnson didn't get put with Hopcraft and Wrench and Johnson stayed on his own and he was only ever heard Johnson in the Court of Appeal, what do you think would have happened?
That's a great question. I think there certainly wouldn't have been anything like the media attention. And I think the Court of Appeal would have found the relationships unfair. The other side may have appealed, but I think on balance they would have left it alone, and you would just have a unfair relationship allegation. Because I'm speculating here, but the other side, and I can't speak for them because I know nothing of how they think, but they may have thought if we appeal this and it goes to the Supreme Court, we'll probably lose. But if it goes to the Supreme Court, there'll be more attention on it. And they may have wanted to keep it away from the FCA. It's possible the FCA would have found out about a Court of Appeal judgment anyway and probably would have done. But
I think both courts actually agreed that they had breached elements of conc as well, though.
Yeah. True. So that it may have pulled in. I don't know. I think it'd have been dealt with quicker. The one thing that jumps out is there wouldn't have been this media attention. Doesn't it? You get Rachel Reeves saying, I will introduce retrospective legislation if Mr. Johnson's unfair relationship claim wins.
Yeah, so I suppose that the media attention would have been probably non-existent or very little. It would have been done with
passing reference, legal press,
business news type,
exactly.
not the headlines that we've seen, not Martin Lewis.
We wouldn't be getting live streamed on Sky. It's 4:45 on a Friday. No.
Yeah, we wouldn't be getting called into ITV studios as we're about to go on an open top bus tour in London and ruining the Sundays.
Yeah, wearing a suit on a Sunday.
Yeah, God. I mean, London in August is not the place for a suit, I tell you that. So obviously Johnson's now the lead authority on unfair relationship. The press have missed it, but it does feel like they are doing the best to try and catch up. I know that the media requests are still coming in. I think there's still a bit to digest.
Yeah.
What do you think this does mean for the UK car drivers?
I think they've got, as I said before, a clear pathway to get compensation through the courts, and I think it's great news because they've got the precedent they can rely upon, and I think they need to get on with instructing solicitors like Sentinel, like HD Law, and getting compensation. The FCA is still waiting around. They say they're going to do a consultation in October. Mm-hmm. I don't know why they won't do it now, or September, but they're going to wait. Perhaps it's to do with the Barclays Partner Finance case in September, perhaps. But the FCA, like I think you said it on your interview with Sky News, that they've been looking into this for nearly 10 years.
2017, yeah.
It's astounding. What are you waiting for? They've almost been waiting to be headlocked into having to do something before they do it. It's the lawyers like myself, like Sentinel, who are getting on with it and taking the charge and fighting the fight, despite that we nowhere near have enough financial resources and deep pockets like the banks. I mean, the legal team, it was in the press, they were getting a dream team together, and Esteemed Silks, who, they're on a lot of money. Mm-hmm. We couldn't compete with that. We kept our team tight. But we're the ones leading the charge. So, as I say, go back to the phrase, back to the notion before, it is a little bit of snobbery towards what we've done and how we're going about it, which I think's unfair. But I do think, and you did an excellent interview with BBC Radio London, that we might get more of the media kind of taking a view and going, actually, there's more to this story. And hopefully your interview with Sky and your interview at ITV and your interview with BBC Radio London gets traction and there's a bit more to it. Yeah. But so far, as I say, gave The Guardian a lot of quotes. All ended up on the cutting room floor. They're just not mainstream at the minute, aren't bothered about the consumer win and the notion that there's a pathway for compensation at the moment. They seem fixated on what does it mean for the car industry? Not, well, what about it? What's it mean for your readers and your subscription payers? Yeah. All the people who pay for Sky, what's it mean for them? Mm-hmm. Because the car lenders, all right, they might pay for adverts during half time on a Super Sunday game, sure, but I'm guarantee Sky get more money from the subscribers who drive cars who've been missold than they do from the big business. But, a lot of media outlets, and particularly the government, contort the body into such a way to please them, which is, again, I keep saying it, it's snobbery.
Well, I think you've made a really good point, and I think law firms and claims management companies are notoriously bad at marketing, unless it's marketing for leads. Yeah, and they're very, very bad at sort of explaining complex topics in an easy to understand way for not just the clients that they represent, but the press. You can't come up there with the legalese and the legal jargon. A lot of lawyers speak every single day and come second nature, and I'm sure they don't. I don't think they realize they're doing it. But the biggest one, and it's things like this podcast that make it clear, that gives people an outlet to sit, listen, try to understand it, and go, oh well, this is actually, we've completely misreported on this, and it is borderline misinformation, like you've absolutely said. And I don't think it was all intentional by the press. I just think they've not got the facts.
Yeah, they've missed the point. Yeah.
And I think ultimately this is why we've got to keep doing the press. We've got to keep calling on the FCA to consult with companies like HD Law, companies like Sentinel Legal, who have been on the front line of this, literally on the coalface of it for years and years. And we've got the rafts of evidence to say, if there is a redress scheme coming, you've been investigating this since April 2017. We're 8 years down the line. You know, HD Law have done the heavy lifting. It's gone to the Court of Appeal.
You've done all the investigative work.
We've done God knows how many trials now. The Supreme Court's ruled on it. What more is it to consult? And the biggest criticism I've got of it is that me and you have both done our separate freedom of information requests to the FCA to find out where they're getting the information.
Yeah.
The consultations that they've done in the past, the 63 firms that they've referred to in a lot of their reports in regards to motor finance mis-selling, when we did the FOI requests, they confirmed that those 63 firms were all representatives of the car finance industry. There was not one firm from consumer law firms such as us that has sat down with the FCA and gone, here's the evidence, here's the disclosure, here's the paper trail of emails from the lenders showing lender behaviour, the redacted documents, the pre-action disclosure applications to receive those unredacted versions, and. And my biggest concern, and we've both discussed this at length outside the court with Bobby Dean, MP, who sits on the Treasury Select Committee, who's a massive advocate for consumers, and I do genuinely believe he's going to do something very, very good for consumers in the way of bringing people like HD Law and Sentinel to the table to actively consult on a redress scheme. But the biggest takeaway is, if you're going to rush this and try and do a consultation that goes live in October for a redress scheme to start in 2026, they cannot do it without the assistance of us, because they do not know the facts. And the conversation about this £950 or less that Martin Lewis is spouting off, that every media outlet spouting off, that the FCA is saying, is from my numbers materially fiction.
We should do a freedom of information request for that 950.
Yeah.
Where's that 950?
100%. Anyone listening to this now, do a freedom of information request to the FCA. Where did that 950 average payout come from in the FCA?
I have little faith at all that the FCA will listen to anything HD Law or Sentinel have to say. We were consulted on, and it happened exactly around the time when the Court of Appeal were hearing Johnson on the imposition of a fee to submit a complaint, the £250, and I wrote detailed, almost written submissions saying this is a real bar to access to justice. How can you do this? And it just got ignored. It was just, sorry, we're going to do it anyway. So I think a lot of what the FCA proposed to do is a fait accompli. It'll happen anyway. I think the consultation is lip service to tick a box to say we notionally said we consult people, and also to make themselves feel like they're given a balanced view. But the 63 firms, they were all from the one side.
Yeah.
The FCA is not independent because its fees or what finances it primarily are paid are from the levies it charges firms. So it's not hard to see how in effect, the lenders are the paymasters of the FCA and the FOS. They think they're doing good for the consumer. Why are you taking 8 years to come up with a scheme on an area that you've investigated and know is bad? They do some good work, and then it seems like the thread's lost, or they lose the impetus to follow through with it. And you're like, okay, good. No, do you want to get on with setting up a scheme? Well, we're going to wait. We're going to wait. Let's consult. Let's wait. They've known DCAs are bad.
They banned them in 2021.
So why aren't you setting up a scheme? As if you've got a DCA, you get it back, and it's also redressed.
Well, they acknowledged in that report that the lenders had broke multiple conc rules. So what has been the how have those lenders been penalised by the FCA alone since they did the ban? Have they been? I've not seen anything to say that the lenders have already had a slap on the wrist for that, because they just said they banned the commission type. So. Anyway, just before moving on in regards to the FCA intervention, I just want to get your take, because this has frustrated me massively. But there's been a lot of media requests for comment, and in my opinion, there's probably yourself and Sentinel and the rest of the legal team for Johnson that could accurately and competently comment on what happened on Friday. there's been a number of law firms, especially claimant law firms and other claimant sort of consumer representatives that have been quoted in the press saying that they're disappointed with the Supreme Court's decision on Friday. Just talk me through, how does that one make you feel as someone who just won in the Supreme Court on Friday? And do you not think that that's damaging to the entire space, especially it's going to compound the confusion by consumers?
Yeah, it does. Well, firstly, they don't understand the decision properly if they're disappointed. They simply, in my opinion, they don't understand it. And it sends the wrong message, and it leans into what the banks want you to say. You know, what the banks want is people to be disappointed and think, well, I best not claim. And the banks are brilliant, we get to retain this profit. The Supreme Court just said that we obtained unfairly because we've got a lot of cases that fit within the factors that the court identified as being unfair. And it's no surprise, in my opinion, why the press are happy to print those particular misleading, erroneous quotes and not me talking it up. I said I was delighted to Sky. I said I was delighted to BBC. No one has said to me, because obviously we were out having a curry, we weren't sat by the TV. It was, you know, well into Friday evening by the time we'd done all that. No one was saying to me, I've just seen you on the telly, which is usually what you get.
Correct, yeah.
And I was a bit like, I wonder what happened to that. I'm asking people, as I say, if anyone did see me on the telly, please email me or yourself. But it's not getting the right message out there. The reason you and I do press is not self-serving. Obviously, we'd like clients and we'd like to have a healthy client database, but it's to spread awareness. It's to get the message out there to help other people.
Yeah, it's to combat the narrative, because that's what happened with the Court of Appeal. We were so far behind on the press that it went out and then journalists were allowed to say, what's the big deal? What's the problem? Why are you not just happy with your car? And it's the stopping of that, and that's why you've got to do it.
I had a smile like Liberace when it came out. I was grinning. I thought, it dawned on me, as I said, I had 45 seconds.
Correct.
And I come out and I thought, I know what to say. Look, I've won 5 times in the Court of Appeal, and I've won twice in the Supreme Court. I've never lost. I've helped millions of consumers, and I'll continue to do so. And I get a kick out of that because I think people who want their money back and are entitled to get their money back have a process through my hard work, and that's great. And a lot of other people have made a lot more money than I have on the back of that. And that's fine, that's how it works. But first and foremost, I take a lot of pleasure in being responsible for cases that have provided a legal framework within which ordinary people like your dad, my mum, your brother, my brother, whoever, can get compensation, get a bit of money back when they shouldn't have been missold, and not feel ripped off. The country feels like it's, particularly since COVID, things are getting a bit, the people are taking the piss.
Yeah.
You know, the price of a pint's going up. You pay for lemonade in London. It was £5.
Yeah.
I was like, £5 for lemonade. And there just seems to be this price gouging, will rip you off, suck it up.
Yeah.
And people are getting a bit like, where's the justice? Where's the natural balance that just tips it back? And I think stuff like this does support, you know, £1,000 in someone's pocket and think, well, I can get a holiday now.
Correct.
I can pay for the gym membership. And that, for me, is great, because you and I are from similar backgrounds. We're working class, and we've gone into the area of law, and we've created, we've established law firms, and it feels good to help those who you grew up with, who you went to school with, who you know in your family, and you're helping the ordinary person. That's our background. That's who we identify with, and that's what feels good to me. And you're trying to spread the message to the press. You're dialoguing with those people through the lens, and then it's not getting out there, and they decide to take we're disappointed, it's a blow, it's a setback. I feel like shaking these people and going, what are you doing? Like, speak to me. I'll tell you what to say. Talk it up. Raise awareness. This is good. Put money back in people's pockets who deserve it most because they've been missold.
Yep.
They just wanted a car, not to be ripped off. They were innocently going to buy a car. That was it. And they've been ripped off.
Well, no, I think you've made some unbelievable points there, and kind of going a bit off piece, but we'll definitely cover this. Is that the way the country is at the moment, and I love talking about this topic. The way the country is at the moment, the British public, they don't have a big brother.
No.
You look at the current Labour government right now.
Yeah.
They tried to intervene in Mr. Johnson's case, a private individual's case.
Yeah.
Then they said that if they don't get their way, they're going to throw the toys out the pram, and we're gonna put in retrospective legislation to undo it. What people seem to forget, they get caught up in the now. They get caught in how does this affect me? What you've just done on Friday is now binding UK law.
Yeah, that's it.
This is going to be decades and decades. Yeah. Johnson will be quoted by lawyers and barristers that haven't been born yet.
Yeah.
And literally the only purpose of Johnson is to protect consumers, to protect people who are not sophisticated individuals, who aren't finance gurus, who don't have a TikTok giving you advice on investments. They are people who want to go in, get a car, get a credit card, get a mortgage, whatever that product is, get whatever that product is, because they need it to live their life.
Exactly. They just want to crack on. They just want to buy the car, like you say, want to get the products and not be ripped off. Mm-hmm. And there's this real imbalance of big business going too far, knowing that they probably shouldn't do this, but doing it anyway. Mm-hmm. And then when it comes to wanting to claim money back, you've got the likes of Martin Lewis going, don't have a level playing field. You don't have a lawyer on your side. You just go to the banks like a lamb to the slaughter and put in your complaint. And the banks will go to the solicitors. Can you handle those complaints? Can you tell us what to say? And the customer or the clients or would-be clients would get like a 5-page letter. Yep. Loads of information and probably get offered £200 or something. But whereas they think, can someone look over this? Yeah, your lawyer could have done that.
But we live in a time where it very much feels like, and you can see the strategic attacks on law firms by the regulators, by claims management companies by the regulators,
and the government,
where the last bastion. I mean, we're called Sentinel Legal. But like, a sentinel is a guard. A sentinel is someone who provides overwatch to the people. You know, this is the last bastion. You know, who else is making sure that this doesn't happen or slowly gets worse? And the reason we're being vilified, the reason that we're being put out in the press, the reason that people are saying don't use a law firm, don't use a claims management, because it's bad for big business, because you hold people accountable. And this is the message, and we're slightly going on a rant here, but this is what people fail to realise. Without people like HD Law, without Sentinel, without all of the other law firms that are running a proper shop and are doing everything for the people, if you didn't have that accountability, that checker, that person that says, if you step out of line, I'm going to come after you for this. If you take advantage of the average person who cannot look out for themselves on these topics, we're going to come after you. And it's going to hurt your business, and it's going to be a pain point. And I think that's what people don't realise.
Well, they don't want you to go and get your big brother, isn't it? Correct. You know, if someone's been taken advantage of, and I'm a big brother,
yeah, exactly.
And I've had my little brother come up to me and you know, I remember someone tried to take his bike once and I ran down the street and got it back. Well, the banks don't want you to go to somebody who will act as a big brother, a guardian, a protector, an advisor.
Yeah.
Which is what solicitors are in this field, claims solicitors are.
Correct.
They give you advice. They protect you against any tactics used by the other side to disadvantage you. And they carry the fight. We carried the fight through 4 hearings over 3 years for Mr. Johnson on a no-win, no-fee basis.
Mm-hmm. Mm-hmm. Yeah, 4 years.
It's the measure of Devereux, Sentinel, HD Law, doing everything they can to make sure that the team wins. Yeah, you know, sacrificing, you know, getting higher fees or doing a different area of law because we are so passionate about it. We are on the right side. This is good work because it you know, what have the FCA said? And again, pulling figures out of the air, but £18 billion going to get paid back to consumers because of Mr. Johnson.
Mm-hmm. If that's not a win, if that's not a win, I don't know what a win is.
I don't know what it is. It could be, you know, double that.
It's not a disappointing figure.
It's not a disappointing. No. I mean, even 1 billion's like a lot. But that's getting pumped back into
people's pockets.
Then it'll get pumped into the economy.
Mm-hmm. Yeah.
Thank you, government, for you know, kickstarting the economy on that front.
No, you make some unbelievable points there. So let's move on to the Sunday announcement by the FCA, which was originally penciled in for the Monday. Yeah. But they brought that forward with, I think we had about 2 hours notice because we found out that the press wanted us to make a comment on something that we knew nothing about was coming. So it just goes to show the press definitely finds stuff out a lot quicker than Mr. Johnson's own solicitor.
Tentacles that stretch far.
Mm-hmm. So the FCA has announced that they're going to be launching a consultation piece that they do very regularly. It's a normal process by the FCA where they do this consultation. They send it out to stakeholders in the industry for comment, opinion, and then they analyse the data and say that it then impacts what they are going to propose as, in this case, a redress scheme. They've said that they're going to announce this in October. It's going to run for a period of 6 weeks, and then they're looking to have a redress scheme live in 2026. Now, for everyone who's listening, the current complaint process is paused. They've said that pause isn't going to be lifted. It's still going for the 25th of December 2025, if my memory serves me right. Yeah,
I think it's just December, not Christmas Day.
I'm sure it says the 25th of September, Christmas Day. Anyway, yeah, they'll probably announce a redress scheme on Boxing Day.
Yeah, that'll catch them out.
That'll catch everyone out.
You're doing press on Boxing Day in the suit.
Bring it on. I'll do it. Put my Christmas tie on. Yeah. But they said that pause could actually be extended. What's your opinion on the whole way that the FCA is currently proposing to approach this? Given your intimate knowledge of the area, the intimate knowledge of what the true numbers are, do you think the FCA should be literally knocking at your door saying, Kevin, when can we have 2 days of your time as soon as possible?
They should, but they won't. Mm-hmm. And I think their approach is slow.
Yeah,
slow. It wasn't unexpected that they were going to do something on the back of Johnson, but then it's like you will do something in October. Now I know there's the Court of Appeal judicial review case that's being heard, but that's not going to get judgment probably until early 2026, so that they can consult whilst the Court of Appeal case is on foot. But it just seems to be very slow, very cumbersome, very reactionary. They wait and then they act. They wait, then they act. And I've got little faith that it'll be a scheme that will deliver adequate compensation. It will just be very rough and ready, one size fits all, in my opinion, like it was with PPI. I mean, the reason why we had so many clients in relation to PPI is because the FCA award wasn't good enough. We had thousands of clients who were like, okay, we'll take that because that's what the scheme's giving me, but I'm still short 3/4 of what I've paid. That is an absolute illustration of an FCA scheme being inadequate, because the idea is the FCA and the FOS in conjunction are meant to alleviate cases going to court. They're meant to be an alternative route for a resolution of a complaint. It didn't work in a lot of cases, and I think the same is going to be again with PCP.
So the redress scheme actually resulted in litigation.
Yeah, it didn't.
Volume litigation.
It absolutely. Yeah, and I have little confidence from my own experience with the FCA and what they've produced when they were last meant to consult law firms over the fee for lodging a complaint. I don't think they took anything on board. I mean, some of the questions were going to do it anyway, style to them as well. I just think they're going to do something that the lenders are happy with, and the claimants will just have to get on with it. But my approach, and I know Sentinel's approach, is to stick to what we know and to do it through the courts. And we think, as we did with Mr. Johnson's case, that's the best route.
To ensure fairness and for the
fairness,
client.
There's a level playing field because we've got solicitors on both sides. You've got specialist solicitors who can take on the bank solicitors, and we've got precedent. I mean, this Johnson applies in the county court system. It doesn't apply at complaint level yet. They're interpreting it, but they haven't come up with something. But you've got Johnson now is the law in the courts, and district judges up and down the land are bound by it, bound by his case. So we, as solicitors, respectively, will stick to what we're good at.
Yeah.
And that's how I see, and I know we discussed this a lot in dispatches, a consumer getting the best opportunity to get maximum compensation is through the court system.
Yeah. So I suppose you think the redress scheme would just definitely be messy and it won't be any consumer's best interest.
Messy, sluggish, diluted, slow, inadequate. I could go on with disparaging words. I just don't have any confidence that it's going to deliver maximum compensation for those who've been affected.
What do you think about this whole opt-in, opt-out comment that they said they're looking whether it's an opt-in and opt-out? You know,
it's like the hokey cokey. I don't know really. I don't know how that even works in practice. Yeah.
What do you think about the my biggest criticism of it is, especially with the claims management companies, is claims management companies, not as a whole, but the vast majority don't have client money permissions. So, there's a lot of them representing clients that, in my opinion, will just be circumvented by the banks when it comes to ultimate payouts. What's your thoughts on that?
Well, if they don't, then the bank's entitled to pay the customer back directly. It's different with court proceedings that they have to pay the solicitors. The CMC area is not something that I think we need to concern ourselves, obviously personally, but it is a factor. But I also don't see how it would work with the fee as well, because it's £250 per complaint if complaints are what are needed. And I don't see how a CMC can continue to lodge all those complaints up front and have the cash flow to do it.
Yeah.
I think the FOS and the FCA, when they introduced that fee, did it on purpose to dissuade complaints being brought.
Mm-hmm.
It is a really disappointing step they've taken introducing that fee. And then they said, well, if you can do it yourself, it's free, which it is, fair enough. But who wants to fill a form in for the FOS? I'm a solicitor, I probably wouldn't be bothered doing it. I'd say I'm too busy, or can somebody else do this? You can have 25% or 20%. I don't mind, because you're doing the legwork. I don't see why that was a bad transaction. It was a private contract between a consumer and another company, and they've sought to circumvent that and said, well, you can do it yourself, And again, I don't want to labour the point, but it goes back to the car wash analogy. But the scheme, it just seems to be very patchwork, ad hoc. They don't seem to be doing it in a concerted, consistent manner. They're just, this has come out, and they're just darting all over the place, going, well, we'll consider this. And they're trying to give the air of everything's under control. This is exactly how we planned it. And I'm just thinking, no, it's not. It's not at all.
Well, I think the fact that they said that they would make a comment 6 weeks after the Johnson judgment came out, and they did it on a Sunday, which was like literally...
Yeah, but they come out and say, I'll tell you in October.
Yeah, exactly. And it just it does genuinely make you think that they're now trying to rush something through to appease whoever they're trying to appease. It's definitely not consumers.
Martin Lewis.
Yeah, to appease something which is ultimately going to, without proper consultation, they're the ones proposing the consultation. So I do stress massively that they do a proper consultation, that it's just going to backfire in the face.
Of consumers. Yeah, because if you could do a consultation, you only listen to lenders. You're going to get a lender-focused scheme.
Of course you are, yeah.
And what's a lender-focused scheme? Can you protect our profits, please, and not?
Can it be slow to disperse?
We'd like to hang on to as much profit that we made through mis-selling, through unfair relationships as possible. We know notionally we have to give something back. That's exactly what they did with PPI. Can we just give a quarter back?
Yeah, and that's what they did.
That's all we'll do. And then everyone's happy. You're getting some money back. We're keeping 3/4. The FCA, pats itself on the back, thinks we've done a scheme 9 years later after we realised there was a problem in this industry. It's terrible. Anybody from coming out from outer space seeing the situation would go, that's crackers. What's gone on here? This is so inefficient. This is really bad for the consumer. It's took claimant law firms acting on a no-win, no-fee basis to lead the charge, to establish the law. Why aren't you doing this yourself? You have the power to set down rules. You've done it. Impose them. It is balmy to me to see how it's playing out from that side. But again, I don't concern myself too much, because I'm purely focused on the court route, because it's what we know best. We know that works. And it's time now, following Mr. Johnson's decision, for you and I to get busy with putting as many clients as we can through that process and trying to get them compensation.
Yeah, with no delay to the clients, because
Exactly.
the clients do not need a delay.
Our scheme's ready to go.
Yeah.
As of today.
Yeah, this is it.
This is it. We're ready. Our scheme's
Business
good to
as
go.
usual.
Yeah, exactly.
There's been a lot of talk in the press, especially from some of the regulators, about cancellation fees by law firms charging, within their terms and conditions, that if you choose to cancel your claim, you'll be charged, in some cases £750 per hour, I believe. I just want to sort of play devil's advocate a bit, and I've got my rebuttal for this, and I've commented publicly on it already. But as a law firm owner, as a solicitor, what's your opinion if you've done work on a file, if a client cancels 6 months in, 12 months in, and meaningful work has been done on the file? What's your stance on charging clients in regards to work carried out? From
my own experience, and I can only speak to that, where we've done work, it will involve issuing a claim and paying an issue fee.
Fees, yeah. Engaging counsel.
Yeah. And you'd have to listen to the reasons why the client wants to cancel and take each case on its merits. But in the past, if a client really just says, look, I want out, you just say, look, we have paid the issue fee. You instructed us to issue proceedings. If you just repay us that, then we write off our fees. It's a tricky one, because I can see both sides, in the sense that I can see the law firm saying, well, you've led us up the garden path. We've done a lot of work. And if you have done work such as issuing court proceedings and you've paid fees, that's concrete action taken on behalf of a client. I can see the law firm saying, look, come on, we've instructed counsel, and you can't change your mind like that. That's not being cooperative. But I can also see if a law firm hasn't done anything to progress the case, I can see a client saying, well, I'll cancel it then. If you've not, what's happened since you took my case on a year? Not that you've not issued court proceedings, or you've not progressed it, or you've not done anything worthwhile. I don't see the problem with.
Hey, you've hit the nail on the head.
Seeking to cancel there, because what have you done really? You've not progressed it. You've got to show something that you've done something, and you're about to do something which progresses the case. Yeah.
Well, I think that's exactly what the purpose of the terms and conditions within your CFA or DBA is for. This is what we'll charge for work, keyword work being carried out.
Exactly.
Not for onboarding you as a client and sitting on it whilst everything's on pause.
No.
If an issue fee's been paid, if a hearing fee's been paid, if counsel has been instructed, if particulars have been drafted, etc., etc.
It's like if you took your car to a garage and all they did was put it up on the thing and didn't do anything.
Yeah.
And you'd say, I can take it. Do you know what? I'll go somewhere else, or I'm going to cycle from now on. You'd say to the garage, well, all you've done is put it up. And if they said, well, we've ordered parts and we've done this and we've done that, look, don't pay for the labour, but we have changed your exhaust. Would you pay for that?
Yeah,
it'd be something akin to that. We'd say, fair enough. I can see you put the exhaust on. I don't want you to do the rest of the repair work. Leave that. Decided to get the train from now on. Something. It's a bad example, I guess.
No, I know exactly where you're going with it.
But you know what I mean? It's that kind of notion. And I think the same applies to law firms. But if all the garage is done is just leave it on the forecourt or put it up on the thing and have a cursory look underneath it, but not done any reparatory work, then I think you've got an argument to say, well, come on. It's all about fairness. I mean, and being reasonable with your client and taking each case on its merit. You might get some clients who genuinely just say, look, I've had a change of heart, and that's okay. Not everybody wants to continue with the claim. But then there's a balance to be struck where you say, look, I actually done, like you say, concrete work on this particular case, and can you just obviously pay back the issue fee or pay back the hearing fee or whatever.
Reimburse us for the work carried out.
If you're keeping the clients updated and you're doing work, I think most of your clients are on board and they know you've been straight with them. You say, look, you might have to attend court and whatnot, and you're upfront and you outline the process and you keep them updated. Most of them come along for the ride. They're in the picture. It's when there's perhaps been a real delay or radio silence that they kind of lose interest in the case.
So it's August 5th now, Tuesday afternoon that we're recording this now. There's quite a lot to go until there's some clarity regarding what the next steps are in regard to a redress scheme. Obviously, we've got the Clydesdale Bank Court of Appeal case in September.
Correct.
Just closing remarks then, sort of, to the FCA, what would you be saying to the FCA now in regards to the redress? What do you think is going to happen throughout the next throughout the latter part of the year, until, you know, things start moving in accordance with what the banks and the FCA are saying?
My message to the FCA would be very simple. Follow Johnson completely. Follow the decision of the Supreme Court in Johnson. Don't water it down. Don't dilute it. Just follow Johnson.
Yeah, I think you summarised that absolutely perfectly. In regards to the FCA, my message has been very clear, and I've said it to everyone now on every single press interview that I've done, is that now really is not the time to be rushing anything, and to rush it would be to the detriment of the clients. They need to look at the evidence. I mean, I've got some judgments here that I was showing you just before we started that show average payments before any costs awarded, before anything, that what we've been achieving in courts across the wins that we've had, and they just don't match with what the FCA is saying. I think now would probably be a good time to close it off. Okay, I'm just going to sort of like hand the mic over to yourself. You know, you've had 72 hours to digest everything. So if there's a message to the FCA, if there's a message to people who are listening to this, if there's journalists listen to this, sort of what is the message from sort of Kevin Durkin, HD Law, the solicitor who won in the Supreme Court on Friday on behalf of Mr. Johnson, that's going to essentially, to quote the FCA, put £18 billion back into consumers' pockets?
Well, firstly, it's been nice to vocalise and get all my views on this. I tried to do it through the press and it just didn't get out there, so there's been a nice release, and it's been really good to talk to you about it after the 72 hours and whatnot, and the weekend we spent in London, just, you know, thinking about what the decision meant. I really hope the message does get out there that there is a defined path for claimants to seek compensation, and with instructing a specialist solicitor like yourselves and HD Law, they have the opportunity now to get compensation. Before Johnson, it was rock solid. It was really difficult. You were having to go to small claims track hearings, run the gauntlet. You didn't have a precedent. You had lenders who were going hard to not get any sort of precedent going in terms of cases being settled, and we've smashed the doors open now. I think in terms of having that Supreme Court decision, this is what happened in PPI, and this has happened again with Johnson. So Johnson is the plebeian of PCP, and I'm delighted that I've been able to talk to you about it. And you know, there's probably not a podcast in the world that's talking about these issues to the extent we are and in the detail we are. You and I were sat there side by side in the Supreme Court. We've faced the music, we've digested it, we took it on board, and now the hard work really does begin, because we need to get on with getting people all the compensation back that they deserve, and I can't wait to get going.
Yeah, and if I just want to slowly just cover off a couple of points you made there. People do not realise that in the county courts, you had 3 or 4 hearings just for one client. He would go to the initial hearing, they'd adjourn it because they realised that they didn't have as much time. Yeah. Then they'd put it to an allocation hearing because the other side said it should be small track. Correct. Or whatever. Then you'd ultimately have your final day, and then the judge would go, it would miss the point, it'd go over the head, maybe
or get a judgment.
It has been unbelievably hard work. You know, with 3 hearings, with three barristers, all charging not on a conditional fee agreement, all charging up front to instruct, to do the particulars. The law firms that have pioneered this space have put their hand in their pocket in a big way, and it's taken, you know, well, look at what you had to do. You had to have the legal fortitude and know-how to take it to where you've taken it. So I think to discount it in any way, shape, or means.
Well, shame on Martin Lewis for doing it, because he doesn't stop. He's unrelenting in his misinformation of, you do not need a solicitor. I'm sure he used a solicitor to buy and sell houses and set up companies, and he's used solicitors. I'm 90% sure, 99% sure. I'm sure everyone does, but he's there saying don't use them. And I'm there with a Supreme Court judgment, the second one I've had, which has helped consumers up and down the land. And he's saying, step aside. So it's been really good to get the message across. It's been really cathartic and self-fulfilling, if you like, to finally sit here after the 6 months we've had, and we look down and we see a Supreme Court judgment with Johnson's name on that you've supported me with, and we've got the right decision. The doors are now open. They will stay firmly open because it's a Supreme Court judgment. And as I say, now it's time to get all our clients and potential clients out there maximum compensation in the most efficient manner. And the court process is the way to do it, in my opinion.
And then one last question I've got. How is Marcus with all this? How's Mr. Johnson?
He's buzzing. He's a diamond of a guy and a brilliant client. He was really good. He's done a lot of press himself, and he's tried to get HD Law's name out there, but they keep cutting it, and Devereux. But he's a lovely guy, a real, genuine, working class, salt of the earth guy. And I'm delighted for him. And if he gets anything from his infamy of being the guy that's helped people get £18 billion, then all power to him, because he's one of the best clients I've had. And I was delighted, and it was an honour to represent him in 4 hearings in 3 years, because I always had him at the forefront. He just went for a car, and he spoke from the heart when he gave his evidence, and he just deserved his money back. He got ripped off, and the highest court in the land have agreed with him, and his name is famous forevermore.
Brilliant. Kevin Durkin, HD Law, thank you very much, mate. Appreciate that.
Pleasure, Sam. Pleasure.